My name is James O'Keefe, and we are going to spend the next hour talking about the First Amendment with a very amazing panel of people. And the subject of this panel is when the government assaults the First Amendment. So thank you for joining us as we discuss the terrifying lengths to which the government will go to silence speech like it does. So
silence.
I am the founder of Project Veritas, CEO of Project Veritas. Project Veritas is a non-profit investigative journalism organization and recent recipient of an FBI raid. Forced entry by FBI agents, which we'll talk about here. This is the subject of this panel. On our panel, we have first Judge Alex Kozinski, is the former chief judge of the Ninth Circuit Court of Appeals, where he served until entering private practice in 2017. Next, we have David Freiheit,
Phonetically, yeah.
known as Viva Frei, Fry, to many of you as a notable Canadian lawyer who also happens to run one of my favorite video law blogs, really takes these motions and makes them come to life. One of the only people I know that does that. And Ron Coleman. Ron Coleman is a partner with a law firm, Dillon Law Group, powerhouse litigation firm blazing a trail for free speech. It should be noted that I am a client of Harvey Dillon. So each of our panelists has firsthand experience with government censorship, something I personally experienced. We have a little video clip we're going to play for you here that takes you through some of these raids. And the first issue on this panel is, do battering rams belong at the door of journalists in the United States? So we have a clip here, if we could get that on the screen.
To execute forced entry search warrant raids. This type of raid led to the death of at least 81 civilians and 13 officers from 2010 to 2016. In order to preserve potential evidence, officers lean on the element of surprise. As police broke down his door in 2010, Todd Blair emerged from his bedroom with a golf club. He was shot to death 5 seconds after the first ram at his front door.
Police, open the door!
The deputies shot 71 times in 7 seconds, hitting him more than 20 times.
And this was the raid by the FBI in New York of Project Veritas journalists.
I'm sorry, so what is this regarding?
This is a search warrant. Open up.
This was what President Biden recently said about such things.
Be seizing reporters' phone records and emails, and would you prevent your Justice Department from doing that?
Only yours, but beyond yours, they prevent nothing.
But honestly,
absolutely, positively, it's wrong. It's simply wrong.
So you won't let your Justice
I
Department
will
do
not
that?
let that happen.
Friday, President Biden said he would not allow the Justice Department to seize the records of reporters.
The president spoke clearly that he won't allow the abuse of power to intimidate journalists.
Is the Justice Department aware that they are not to seize the records of reporters?
Everyone, I think, is aware.
And so another clip here of these raids, which are unannounced and people often die.
Dynamic entry raids often begin with unreliable informants and cursory investigations.
And finally, testimony before Congress people about this. Ashley Biden's attorney, a woman named Roberta Kaplan, responded by saying, quote, "We should send to the Southern District of New York," unquote. In just 24 days, Ms. Kaplan got her political favor fulfilled when the Southern District of New York approved the first of 19 secret subpoenas. So, So this is chilling footage, and it kind of begs the question, is there ever a circumstance in which a journalist's reporting should result in a forced entry raid like what we just saw? Judge Kaczynski, you were born under socialist rule. Was it Romania?
Communist.
Communist rule. Communist rule. People generally think governments attacking the press is a uniquely Soviet or communist thing. I've heard some say it is in fact now the new America. So is freedom of the press under attack in the U.S.?
Absolutely. First of all, happy Bastille Day.
Bastille Day.
It is. Another day dedicated to freedom. We think we should celebrate it. It's another day dedicated to freedom. We think we should celebrate it. And because as such, they're getting so much fewer. As you said, I grew up under communism. I know very well what it is like where the approved organs of the government, the press that the government either owns or approves, are treated differently, and everything else is suppressed by often brutal means. You could get shortwave radio, Radio Free Europe, Radio America, but if they caught you, they would break in your house and you'll take your radio and you would not see the light of day for years. So this is really an astonishing and incredible development that they're doing this to the press here. I should say there are circumstances, and I think we need to be aware of them, where there are certain dangerous criminals, drug dealers, kidnappers, murderers, where police have to go in unannounced and break down doors and use weapons. But every one of those enterprises, every time they do it, this is an extremely hazardous enterprise. People get killed all the time, victims get killed all the time, police get killed all the time. And there's no justification for doing it when there's no evidence whatsoever, whether they are journalists or anybody else, that there is any danger involved. Now, this is a tactic that's been used by American law enforcement now for at least 10 years or maybe longer, where they will target somebody, they want to shake them down, they want to rattle them, and so what they do is they will send a SWAT team in the middle of the night to arrest them, and then notify the local or national press so they can be out there and watch the individual being taken out in handcuffs and walked to the car. It's an intimidation tactic. It's a very dangerous intimidation tactic. It's not limited to journalists. It happens to all sorts of white-collar criminals where there's no indication whatsoever, accused criminals, I should say, where there's no indication whatsoever that there is any danger, and there's no excuse for it. I've called out the government on this on more than one occasion, and it's fallen entirely on deaf ears.
Ron Coleman, is this attack on dissenting reporters new, or is it just that it's more visible now?
Well, James, Judge Kaczynski made an excellent point just now. What we're seeing that's new is that the line has been crossed into using it against journalists. That would have been understood as a tactic that was off the table until fairly recently. I was involved in a case, though, and I did a lot more trademark work, where I represented a little old man who was a member of the Guggenheim family. And he had a bit of a habit of encouraging people to invest money with him under the impression that he was that much more of a member of the Guggenheim family than he was. When the Guggenheim Financial Services Company got wind of this, before they filed their trademark infringement case against him, they contacted the Southern District, just like on an email like that. And the thing that people have to realize that's terrifying is that the Southern District of New York is a private police force available for the use of major law firms for a wide variety of things. And they did exactly what Judge Kaczynski just described. They raided the guy, an old Holocaust survivor with a gimpy leg, did the perp walk, went to the papers, and of course he had taken no money from anyone. He was just a Was there maybe some trademark infringement involved? There might have been. We're talking about trademark infringement here. It would have been unthinkable to cross that line with respect to journalists, but remember, I don't have to tell you this, there has been a concerted effort to deny the right to call yourself a journalist to anyone who works for a brand that wasn't recognized as a journalism brand before the internet. So you and OAN and barely Fox, you're not considered to be journalists, you're considered to be something else, something less than journalists. Would they have done this even to Fox? I don't think so, because those are recognized brands in the journalism entertainment business.
Well, they tried doing it to that Los Angeles reporter, but there was so much pushback in that case. Viva, as a Canadian attorney, looking at this through an outside lens, what's your perspective on the freedom of press in America right now?
Oh, well, I've been following James for longer than you've been following me, because I couldn't believe the type of journalism that you do, and I'm not putting it in scare quotes. And I said at the time, seeing James call out, dig up dirt on powerful people, I said, how does he not get harassed more than he does? This was before you really started getting harassed. And the tactic that the government and the media does with dissident media is ignore, demonize, and then brutalize in that order. They'll ignore you until you become too powerful to ignore. Then they'll demonize you, so they'll call you all the names that they call you, James. And then when that doesn't work, they'll brutalize you with the weaponized full force of the law. Going after you, and I've been following the seizure, the warrant because of a diary that was allegedly stolen.
Not by you.
I said, when I heard this, it sounded like a setup. And I said, this sounds like a setup. Someone's given this to you so they have an excuse to go after you. I might be a little too black-pilled, as we say now, but it's exactly what ended up happening. Setting aside the content of that diary, which might be much more relevant now given the content of other materials that have been hacked, it's a pretext. It's a pretext to go after, brutalize dissident media after denying that they're media in the first place, and distract you with the procedure so that you can't actually do what you're doing. It's a tactic.
And only against disfavored media would they go after MSNBC or CNN. I mean, this idea that, the new media is not media is entirely bogus. I mean, we have been changing, media has been changing throughout our history. If you look back to the pre-revolutionary days, the authors of the Federalist Papers were not established media. They were people who were writing pamphlets, often anonymously, along with many others, and getting their ideas distributed. And nobody, if you'd asked them, Ben Franklin, are you, or Hamilton, are you in the part of the media? They would have said no. I mean, that's not what we're doing.
You go to the National Press Club, annual.
So this distinction as to being established media and being not established media is just entirely bogus. Media changes as technology changes, as the world changes, and it has to change. It has to change and has to take account of new technology. In Romania, the two newspapers, Scanteia and Romania Libre, those were and the two radio stations, those were the official press. Shortwave, which was different technology, was considered to be illegal.
As a federal judge, this is a big deal. You're a chief judge, Ninth Circuit. Have you ever seen, in your tenure as a federal judge, you're appointed by Reagan, correct? So you were on the bench for decades. Have you ever seen the FBI raid journalists' homes?
Never.
James, one reason that it's possible now, one reason we crossed that line was not only the polarization politically that took place with the election of Donald Trump, but the changes that Judge Kaczynski is referring to here have made the established media brands behave in an anti-competitive fashion precisely because they are no longer remotely interested in investigative journalism or in any way reporting on news that doesn't favor their partisan interests. Their entire interest, in fact, is in shutting you down, not only because of the ideological competition, but because of the financial competition.
Well, so you represent D.C. Drano, correct?
Yes.
Speak a minute about the censorship there and how that pertains to this First Amendment issue.
Well, one of the ways that the state has taken upon itself the moral framework to become censors, there are two that we've experienced in the last few years. One is in connection with the plague, right? You just had the panel that spoke about that. So social media has censored a wide range of voices about people who, including sophisticated, highly respected professionals who had different ideas about how to treat COVID, and as well as ideas about the vaccination. The other one is elections. In 2016, we all know that the Russians hacked the election, but in 2020, it became essentially against the law, a law that was never passed and could not be passed, but essentially it became a crime against the state to question election security. A decision was made by the social media powers that be before the election took place that they would become a willing tool of the state to enforce that censorship. A coalition of attorneys, state attorneys general, almost all of whom, as I understand it, were members of one party, set up a system whereby they would monitor social media for things that might cause hurts to election security. D.C. Drano is a young man. He's a lawyer. He worked briefly in law before realizing that he could have a lot more fun, like David here, rather than practicing law, doing things on social media. And in particular, one of the things that he realized was that by being an influencer, he could make a lot of money, and he does. He has about 3 million followers on Instagram. And he had a pretty, his name is Rogan O'Handley. And Rogan, he puts up memes, he pitches stuff, it works great for him. He had a substantial following on Twitter. At one point after the election, Rogan put up a tweet in which he questioned whether or not Joe Biden had been elected as reported, and suggested that the state of California's election security should be audited. A short time later, he was taken off Twitter. He was banned from Twitter for spreading election misinformation. This was in January, after the election. But the People's Commissariat of Election Security, in this case, the State Department of the Republic of California, the People's Republic of California, I should say, had reported his criticism, Rogan's, of election security in California as a threat to election security. Now, anyone who's involved in cybersecurity knows that the way you test systems for their security is by running what's called a pen test, a penetration test. The way you trust any system, the way you see if a tire has got a hole in it, you put it in a tub of water and you look for the leak. So the idea that by suggesting there was a problem with election security was a threat to election security makes it very clear that what the threat was a threat to the political regime. It wouldn't have mattered anyway. It was an entirely inappropriate use of government power and of Twitter acting as an arm of the United States government. In fact, what we learned thanks to a state-level FOIA request by Judicial Watch, which does what real journalists used to do. Absolutely.
Well, I should say, too, that Project Veritas was banned from Twitter for accidentally posting in one of our video camcorders on a public street a lamp post with the number of someone's house. That was the excuse that they made for taking Project Veritas off Twitter. But
James,
yeah,
the test run was with Alex Jones. What they got away with Alex Jones, that was the setting of the bar to be done to others, to just unperson, deplatform, demonize, so that the society as a whole would accept it because they're bad people, they need to be deplatformed. But the description that Ron's given, this unholy alliance between government and media, as far as I understand, it's the actual literal definition for fascism. When you have the government and the media doing each other's bidding, it is fascism.
Now, and let's transition to another topic that's absolutely fascistic, I would say. There's no better way to silence a journalist than to steal his reporter's notes and dox his anonymous sources. Sources are critical with journalism, and protecting those sources are codified in the First Amendment. So we have another video here we're going to play for you. If we can get that on the screen. This is Brian Stelter at CNN. Brian Stelter talking about under the Trump administration, there was an attempt to gag the New York Times, which uses Google as an email client, and Stelter is rightfully indignant about that.
Gag orders against the American news media. That sentence doesn't make any sense, right? It's oxymoronic. The media can't be gagged, sure shouldn't be gagged, but that is exactly what happened. The government enforced a gag order against the New York Times in a leak investigation earlier this year. There's the front page headline. Justice Department waged secret fight to get emails of Times reporters. And the Times couldn't even talk about it. The newspaper's lawyers were gagged. They couldn't even tell the people involved about this secret fight. This is part of a wider pattern seen first in the Obama years, then in the Trump years, of leak investigations that end up involving snooping on reporters. So let's just be clear here. Spying on journalists is an affront to the First Amendment. There's no place for it. And now, notably this weekend, President Biden's Justice Department says it agrees. This DOJ will no longer seize reporters' records.
So the Biden DOJ says in this is the spring or summer of 2021 last year that they're not going to do this, and then while the Attorney General and the President are saying this happens.
We learned that the Biden Justice Department targeted Project Veritas, having its emails seized on Microsoft servers.
And to make matters worse, the government can send gag orders with these subpoenas that prevent service providers from telling the targets that their information has been given over to the government.
The DOJ used secrecy orders against Project Veritas. The DOJ then went behind the judge's back to obtain an extension on 2 sealed non-disclosure orders.
This is the memo from the Attorney General of the United States dated July 19, 2021. The Department of Justice will no longer use compulsory legal processes for the purposes of obtaining information or records from members of the news media. While the Attorney General was issuing this memorandum, the Southern District of New York went to various magistrate judges to obtain 200,000 emails from Project Veritas journalists and then gagged Microsoft from telling anybody about this.
And did Mr. Potato Head speak out in your defense?
Did who?
Mr. Potato Head?
Mr. Potato Head, no. No, we have not heard anything from Brian Stelter, but we are suing CNN for defamation.
This man
so
knows
there
his
might
means.
be.
But that's the whole deal. I mean, if you were embarrassing, if the stuff you were doing, you are embarrassing what they consider to be the sacred cows.
When you say the whole deal, do you mean that there needs to be this indignation from the establishment press for there to be justice?
No. They only are indignant if you're embarrassing people they don't like. If you embarrass, if they embarrass people they like, they're not going to be indignant. They're going to say you have it coming.
It comes down to whether they like us or not.
Well, they like you, and you like your message, and who you're embarrassing.
James, the argument's easy. You're not a journalist. Yeah, you're a spy. You're a negative force that needs the rules of journalistic standards don't apply to.
And you knew that.
It was in the New York case where I think the prosecution argued that you weren't journalists, and the judge said, "Look, I find it hard to believe that if you said Walter Cronkite was doing what James O'Keefe was doing, you wouldn't consider it journalism." But it's the tactic, and in Canada, they're trying the same tactic now by disqualifying people as journalists.
So it really comes down to this. The heart, we talked about this backstage, even in the law, in the eyes of the law, it says news media. So much of justice here strikes, it depends upon the definition of a journalist. So what is the definition of a journalist?
When blogging was the thing, and I was representing a lot of bloggers, we tested a lot of these issues. We briefly had an organization called the Media Bloggers Association, of which I was the general counsel, and we argued for the proposition that bloggers were entitled to the same protections. The people whose platforms were blogging and who did journalism were entitled to the same protections as people whose platforms were, at the time, newsprint and who did journalism. To quote the great Insta pundit Glenn Reynolds, journalism is something you do, not something you are. That's a point that judges had a lot of trouble with in the 90s because most of them were not particularly computer literate, and the internet, especially social media, were in its infancy. Now, I think the situation has improved markedly. I think judges are harder to buffalo. The thing is, in the Southern District of New York in particular, there are enough magistrates, especially considering the percentage of magistrates in that court who are former prosecutors, that eventually you'll find one that will give you what you want.
So Judge Kaczynski, as a judge in federal court, is it normal for the government to seek warrants and subpoenas from so many different, there were some 6, 7, 8 magistrate judges that the DOJ went to obtain our reporters' emails? Is that normal?
You know, I knew you were going to ask me this question, and the answer is I don't know. What I do know is that courts have a procedures in place to avoid judge shopping. So, for example, if you bring a case and there's another case that's related, you're supposed to advise the court. Or there are strict rotations of where judges are drawn for cases where they're randomly assigned. So there are procedures. This is something that the courts are very aware of, the judge shopping problem. You know, going to one judge, not getting what you want, going to another judge, going to another judge. I'm not sufficiently familiar of how it is they went to 9 different judges. So I'm not prepared to say it was not legitimate. It may have been different cases, different time periods, it may have been different courts. So I can't
Well,
speak to that.
in December of 2021, the federal judge, Judge Annalisa Torres, assigned a special master over the FBI,
Yes.
citing journalistic privileges. And after that point, the government went back to Microsoft and continued to try to gag them from telling anybody that they'd taken our emails. So if you were Judge Torres...
The one thing judges do not like is having, take great umbrage at, is having their orders disobeyed. Again, I haven't read the order, I don't know exactly what they did, but judges do not like being fooled and do not like being...
Viva?
Well, James, I say you might have the curse of too much knowledge. For anybody who doesn't appreciate what's being discussed here, Judge Torres issued a special master in one case to do the triage of documents that were seized on Project Veritas cell phones, so the prosecution wouldn't necessarily see anything they weren't supposed to see. Undisclosed to that Judge Torres were previous orders where the prosecution already had access to all of that information anyhow, so the special master appointed was effectively irrelevant and effectively led one judge to think her order was being respected when it wasn't at all. And like Judge Kaczynski says, if I'm as a human, that irritates me.
And the government did not disclose they already had these orders?
They did not disclose to Judge Torres.
They didn't because there is no accountability for prosecutors in this country, state or federal. There's none.
But there can be.
But so how, that is something that everyone in this room is probably thinking is, but no one's ever held accountable. Nothing ever happens to these people, which was going to be my final question, and we'll get there. But you said that accountability is possible. How so?
It is possible. I think judges need to take this very seriously. If a court is lied to, it needs to say so in no uncertain terms and identify the parties. I wrote an opinion 25 years ago, a case called United States versus Kojayan. You can look it up. And what happened in that case, the government repeatedly lied to the court. And what I did is, along with my colleagues, we were unanimous, wrote an opinion saying the government lied. We identified the lawyer. who lied, by name. And we identified the supervisor by name. And my understanding is, this happened 25 years ago, that opinion was circulated for decades in that U.S. Attorney's Office. And when new lawyers came in, they were told, better be careful, you might be Kaczynski.
Ron Coleman.
If judges did this, if judges took this seriously, it would make a tremendous difference. The FISA court issued an order. We're all familiar with the order where they said a lawyer lied to the Justice Department. The Justice Department lied to the court, and we are so outraged about it. And then they did basically nothing. They didn't name the lawyer. They didn't do an investigation. They didn't charge anybody with contempt. Basically, what they said is, oh, we're so unhappy about this. But the FISA court is exactly a place where you need total candor from the government, because not only is it ex parte, but most of the time there's never any disclosure to anybody. So there's never any opposition.
It should be noted that transparency, the ACLU is defending Project Veritas, which usually makes people react, and they're trying to unseal these affidavits. But Ron Coleman, before the internet, if the government wanted your records, you'd know. They'd come to your door, they'd take your literal notebooks, they would subpoena them, and you'd know about it. But now with this advent of the cloud, the principle here is that if your emails are housed in a cloud and the feds can go get secret warrants to obtain them.
That's assuming, James, the NSA hasn't already gotten them outside of that process entirely and bled them through channels to the Justice Department or the FBI so that they would know what to ask for and where to find it.
So how does a journalist do their job? How do they protect their secret government sources?
At great risk.
Scribble it on small pieces of paper, and if need be, swallow them.
Scribble them on pieces of paper.
James, in the old country. James, one thing, when you talk about accountability, like I don't mean to be too black-pilled. There can't be accountability in this fascistic regime where you have the media not acting as the watchdog of the government, but as the lapdog of the government. And when they're there, not scrutinizing the government, but carrying their water, and not challenging them, but amplifying them, you've got what Nancy Pelosi referred to as a wrap-up smear, but at the judicial level. You got one party doing the bidding of the other, and the other one covering up the wrongdoings of the other.
And you had a point to make about that?
Well, I actually have a solution, a possible solution proposed, something not general at all. This doctrine goes back long before the internet. There was a case in 1975 by the name of Miller. And what the Supreme Court held there is, if you give your money to a bank, then you don't have any privacy interest in it. So if you have $1 million, whatever sum, you keep it in your mattress, it's yours, you're private, the government needs a warrant to come in and search your mattress and find it. But if you turn it over to a bank or any other institution, then you have given consent to a third party, and when you've given consent to a third party, you've given consent to the government. That's called the third party doctrine. And it needs to be rolled back. It needs to be attacked, and it needs to be challenged, and it needs to be rolled back because it now applies not just to banks, it applies to everything. It applies to your internet provider, it applies to your websites, it applies to just everything you do, your post office, everything that you do goes through the internet, which means you have consented. Once you go outside your home, you have consented to give this information to the cloud or whatever. You've disclosed it as a third party, so you no longer have Fourth Amendment protections. So it just is outrageous because this winds up being most of what you own, most of what you know.
Your search histories. Your search histories. What do you think Google doesn't know about you? It's there.
So preventing the government from illegally taking your things is half the battle. And then once they've taken your things, you have to get them back.
Good luck.
Exactly. Which we're going to talk about the good luck portion of what you just said. This is Harmeet Dillon. Ron, you work with her, and she's on Tucker talking about some of the nuances regarding this case.
Warrants from different judges in the Southern District of New York to spy on Project Veritas's emails. To date, it looks like Project Veritas has been spied on to the tune of 200,000 emails that the DOJ secretly collected, and by the way, also did not tell a federal judge who is overseeing the seizure of our clients' materials from journalists who worked on that Ashley Biden story, which, by the way, Project Veritas never even ran with it. And so what the DOJ has done is weaponized the DOJ to spy on a journalist.
This is the petition, the motion that sits on the federal judge's desk to get back the stuff. It's called a 41G motion
That could happen
that we filed. So I guess the question is, you know, and we know the answer, but I want to know why. Would this ever happen to the Washington Post or the New York Times or, I don't know, these established organizations? And the answer is it won't. But why not?
Because Mr. Potato Head would, would have a hissy fit.
Well, wait a minute. There is a case that actually did raise the hackles of First Amendment types, which actually did involve a gag order on the New York Times. And it's a case that you know.
Maybe talk about the nuances of that case. And because they didn't actually, the Trump DOJ didn't actually go through with it, or did they?
Well, what happened was, in light of all the arcs and rays between you and the New York Times, again, you have a pending defamation claim in the Supreme Court of the state of New York, the county of Westchester, against the New York Times, which, as we know, passed the motion to dismiss claim stage. And while that was pending, the Times found itself a little bit involved in the raid on your house. Strangely enough, they knew about it very, very quickly, like while it was happening.
I got a text message from a national security reporter right after they took me out of handcuffs who knew everything about the search warrant and the deal.
They got the photo up because it's part and parcel of the demonizing, then brutalizing. They got the photo up. They did the same thing with these pre-dawn raids of Roger Stone, Paul Manafort.
But Roger Stone, this goes to the point that Judge Kaczynski, that's a dangerous man. That's a guy who, you know, with his skills, those deputies could have been all laid out in no time at all.
Judge, you said good luck getting your stuff back. The government has over 40 or so items that they seized from our reporters, laptops, et cetera. They actually have 2 of my phones. They still have these things. Does the law allow the government to hold seized items indefinitely? At what point should the government be forced to either indict me, which would unseal the probable cause they used to obtain the warrants, or give the property back?
You know, the formal answer is no, they can't keep it forever. The practical answer is yes.
What does that mean?
What that means is, under federal law, and they can seize property, assuming this is not contraband, if it's drugs or, you know, something like that. But this is not that. These are things that would be used in an investigation or that could be used in court to prove a case. And at some point, you're entitled to go into court under 41G and ask the court to force the government to give it back. And the government comes back and says, but we still need it. We are still investigating.
But at least we know that there's something called the Speedy Trial Act.
Well, the Speedy Trial Act only kicks in if you have an arrest or an indictment.
No, but I'm saying that the government's ability to make excuses, and as you said, there is a formal rule, and then there's what we've seen in connection with the January 6th prosecutions. There's a certain amount of discretion always given to trial judges in a broad range of categories, and the discretion baked into the Speedy Trial Act has been so routinely abused. And again, in that, you know, when the government comes back and says, so there's also something else that non-lawyers have to understand, which is that there is a presumption, it is actually a legal presumption. The government doesn't appear in the courts as an equal to a defendant, even though you would, technically speaking, the burden of proof is on the government, and therefore you would think that they should have to be the ones doing the heavy lifting, but both culturally and socially, as well as in many legal doctrines, and you always have to be careful when explaining the law in the presence of the court. So, but the government can get away with stuff that private lawyers can't. They can make excuses that private lawyers can't, and they're gonna get the benefit of the doubt, because if you're a judge, you don't want to be the guy who let the mobster off on a technicality. And that's how it goes.
Well, James, you'll get your phones back, but when you're talking about digital information, you're never going to get that back, because you're never going to know if they'll sign a certificate or an affidavit of destruction of evidence. It'll be the same prosecution that concealed the fact that they had this evidence from one judge when they knew that they were banking on it in front of another judge. It's gone. They have it forever. All that they wanted was lists, names, donors, sources. They've got it. You'll get your phones back.
It seems as though the constitutional crisis is once you take those anonymous sources from the notebooks, even if they're electronic notebooks, same thing, that what possible remedy is there for the affected or aggrieved journalist at that point in time?
It's going to be black-pilled Viva today, but there is no effective remedy other than oversight and sanctions for abuse,
what is oversight and sanctions? How do we do that? I have my answer. I'm just curious what yours is.
I mean, we all know about the Kleinsmith lawyer who didn't just lie, but falsified evidence by manually redacting information, submitting it to a FISA court or having it submitted, obtaining an unlawful renewal of a FISA warrant, was caught, pleaded guilty, 1 year retroactive disbarment, and no prison time. And he'll probably be lauded as a hero because politics ruins everything, and what he did for the good of the party. There's oversight and punishment.
Kleinsmith has been readmitted to the bar.
Yeah, it's over. He's back in business.
He was disbarred for 6 months.
No lesson learned, no meaningful punishment.
The argument the government is going to give is, we have this piece of evidence. Let's say it's not a phone. Let's say they go into some place and they find a dagger with blood in it.
Yep.
I mean, let's just say that. And they keep it, and they're investigating. And the owner of the dagger must come to court and say, look, this is my knife I used to cut beef with. And the government comes back and says, well, we're still investigating. We're not sure. We took samples. They're not panning out. And we got to ask more people, where was the dagger bought, and so on. The government can tell a pretty good story for a very long time as to why it should not give back this piece of evidence. And again, having been a judge for decades, it is very difficult to second guess. Not because you have a great respect for the government or anything else, but they tell you, we need more time to investigate.
Well, it should be noted that the crimes in this case, the warrants, the statutes that were transporting stolen documents across state lines, which at the Washington Post and New York Times is called Tuesday. But what is, you mentioned accountability. Let's go back to the accountability issue. How do we solve this? Because it seems like things are so broken in our Justice Department, and it's self-evident by the fact that they're, I never thought this would happen. 2 years ago, I didn't think they're pointing guns at us now and just taking our stuff and saying that you are transporting stolen, I mean, this is absurd. So it seems like you're not very hopeful here about getting our stuff back.
I'm not hopeful about you getting your stuff back. I am somewhat hopeful about changing the culture. Keep doing what you're doing. Keep embarrassing them. They hate it. They hate being embarrassed. They hate being shown that they don't follow the rules that themselves that they apply to others. They hate being shown to apply different rules to different people based on criteria that they say are irrelevant. So you and others out there who are in the business of, I'll call it counter-journalism, but it is journalism, but counter-journalism, counter in the sense that they are not mainstream, who are telling the truth, are getting more and more and more people to listen. As reality keeps eroding the viewership and the credibility and the visibility of what the mainstream press is, doing the kind of stuff you are doing and doing the kind of stuff that you guys are doing is tremendously important. And you just never give up, never apologize, never concede, because you are right.
Never concede.
James, I mean, I would say that the solution is sort of like a top-down and a bottom-up, and at the same time, and you just hope they meet somewhere in the middle. You got to keep exposing the corruption, the hypocrisy, and you got to make it cool to not tolerate this crap because of politics. It's not because your ally is doing it that it's acceptable. And one way to, sort of set that standard, if anyone didn't get the reference of Potato Head before, that's Brian Stelter's online meme name, Stelter.
Is that his name?
No, they call him a potato.
They call him Potato.
Potato Head?
No.
So
the head is the least of his problems.
The idea is that, Stelter, if he had the slightest bit of dignity, would be as outraged when what he was complaining about against the New York Times is performed against Project Veritas. But politics guides him like blinders on a horse.
It should be noted that the Reporters Committee for Freedom of the Press, Ed Snowden's organization, the ACLU are defending Project Veritas in this case and have requested the judge unseal. But you're right, some other organization, New York Times, has been assigning their entire national security team to investigate me. So there does seem to be a division in the press between people who actually believe in principle and then just believe in personalities or fiefdoms. I don't know if you want to speak to that, Ron or Viva.
Abe Rosenthal is long gone. The idea that the Times or any of these media institutions, these media corporations are higher or better or dedicated to some public purpose is preposterous. They are ambitious, highly credentialed, well-connected people, and they're mostly interested in furthering careers as in any other field. Where you find the spunkiest and the most independent-minded and the biggest risk takers are here, in this room, on this stage, people who are willing to make a little bit less, make a lot less, but to do things that matter. And that's what it's about.
On the topic of the New York Times, everybody should read the book, The Gray Lady Winked. People think it's worse now than it's ever been. I think the reality is it's always been this bad. It's just now much more exposed. And the more people keep talking about it, the more people learn, and eventually they say, enough is enough. The New York Times can't get away with this, they shouldn't get away with this, and they don't deserve to get away with this just because they are on a pedestal.
But the fact that journalism sounds to me like you're saying that must be done by people who are not part of the credentialed media, but yet the law treats those people differently. The law would, I think it's self-evident that the FBI is not going to just start raiding the New York Times and CNN and the Washington Post.
That's not the law.
That's not the law.
That's a government agency that has law enforcement powers that is part of the executive branch. It's true that depending on the executive, they may or may not listen to the executive, but it is not the law. The law, I have said, and I said it well after Judge Kaczynski retired, that in the present crisis, everyone knows that the executive branch has failed, and everyone knows that the legislative branch has failed, but not enough people appreciate the extent to which the judicial branch has failed time and time again on the Trump election cases, on the COVID cases. It is such an extraordinary lack of spine. I think, and I would love to have this discussion with Judge Kaczynski, I think the internet has made judges look over their shoulders at what other judges are doing, much more than was the case when I came into the profession. And, minute reports came out months after decisions were rendered, and people took their times absorbing what was going on. Now, everyone knows that all the judges are throwing out the challenges to the election. I'm not going to be the first judge not to do that. That's the top-down stuff we have to worry about. Have we seen a recent reassertion of some spine by the U.S. Supreme Court? Maybe we have.
How about I'll leave the judge with the last comment here, running out of time. I mean, I would think maybe the Article 3 judges are the least corrupt area in modern society. What do you think about the judiciary's ability to do the right thing in present times?
Well, I agree. I don't think our judges are corrupt, but I do think they live in the real world and they are fearful. And they are worried about making decisions that are going to make a lot of waves. I mean, look at what happened recently in Washington with Justice Kavanaugh. Assassination attempt and then being harassed in public. No judge wants to visit that upon himself and herself and the family. Fortunately, we have a number of principled federal judges, and I think there'll be enough in the judiciary that they will come to recognize the justice of these claims.
Well, these two motions are on the desk of Federal Judge Annalisa Torres to return our equipment and unseal the affidavit, so fasten your seatbelts because either way she rules, it's going to be an amazing journey. Thank you all for joining me for the First Amendment panel. We appreciate it.
Thank you.